Defense lawyers of Reddit, what is it like to defend a client who has confessed to you that they're guilty of a violent crime? Do you still genuinely go out of your way to defend them? Story 1 public defender here. I describe my job as part doctor, part tour guide. Like a doctor, sometimes I can cure you, but sometimes I can just try to make it hurt less. Sometimes I can't do either. Then I'm a tour guide who makes sure that you understand what is happening, why it is happening, and try to give you as much choice in the matter as possible. At the very least, I sit next to you in court so you don't have to face the judge by yourself. Story 2, I'm a defense lawyer. 95% of clients are factually guilty. No, it makes absolutely zero difference to our motivation. It's a huge misunderstanding that the justice system determines guilt and innocence. It doesn't. It determines whether the state has enough evidence to lock a human in a cage against their will. So a client asterisk actually asterisk being guilty has nothing to do with that question. Moreover, the asterisk vast asterisk majority, 90+%, even if you're a very aggressive attorney, end in a plea. The issue is usually that your client is guilty of asterisk something asterisk for which they have sufficient evidence, but the state has overcharged. You find a reasonable balance based on the strength of the state's evidence. A trial is a broken negotiation, and typically only happens if one side is being completely unreasonable, is dumb, or has nothing to lose. Edit. Hi all, I don't have time to reply to everyone individually, but let me address the biggest topic of conversation: overcharging. Couple points. Yes, it happens all the time. Asterisk all the time. Asterisk, especially in lower income communities. Police and prosecutors start from the asterisk very highest thing they could possibly charge. Asterisk here is, what asterisk doesn't T asterisk happen, which has been brought up a lot in the comments. Guy steals a pack of gum, state charges him with murder, we plead a robbery. Bargaining in a legal case isn't like haggling for a car. There's not a high ball and low ball, and we land in the middle. That's because the defense is, supposed, to see the evidence, so we asterisk no asterisk what the reasonable charge would be. It's more like this. Guy steals a pack of gum. Stage charges, robbery, battery, assault, and resisting arrest because they allege a scuffle happened during the theft. I look at it and say, okay, the state's got great evidence of the theft and really weak evidence of the scuffle and medium evidence for resisting arrest. So we'll plead to the theft, off with the robbery, battery, and assault, and we haggle over the resisting. If I think maybe asterisk, they get the robbery, then I advise my client to eat the resisting because it really doesn't add to much, and the penalty for robbery is 10 years. If I feel confident that they're fucked on robbery, we hold strong and only plead a theft. So basically, if you have a good attorney, we just bash through the overcharging. Does it move the needle? Yes. Do people cop to charges a asterisk bit asterisk higher than they should because of the threat of the overcharged crime? Yes. But are people pleading out to absurd things they didn't do because the state is waving bogus murder charges over their heads? No. Good attorneys don't let that happen. Story 3. It's about holding the state accountable. I don't care if my guy did it. If we let the state lock him up without doing its job properly, that means next week it could be you, or me, or your mom that gets sent up for something we didn't do. Story 4. The point of a defense lawyer is not to get people off their sentence, but to ensure the right to fair trial is upheld. Defense lawyers in that situation will be looking for leniency in sentencing to make sure the justice process doesn't become vindictive or vengeful. Story 5. My criminal law professor said that he preferred guilty clients because he could do his best to ensure a fair procedure, but if he lost, he didn't sweat it. He took it a lot harder when he would lose a trial for a client that he thought was innocent. Story 6. I'm late to the party, but one thing I've noticed is missing from many top comments is discussion of a lawyer's ethical obligations to the bar and to the court. If your client confesses his guilt to you, you cannot elicit false testimony from your client on the stand. You cannot knowingly present false information to the court, and if you become aware of that falsity after the fact, you have an obligation to correct the record. It can get complicated with things like your client testifying. You can choose not to call your client's friend to the stand if you know he will lie, but your client has an absolute right to testify. When you know that your client is guilty, but he insists on testifying that he is not, you can have him give narrative testimony in which you, as his lawyer, do not participate. The standard is typically whether or not you know that something is untrue, not whether you strongly suspect it is. Story 7. I am a defense lawyer as well. TLDR. The criminal justice system is so oppressive, I don't care so if a guilty client or two gets off scot-free. On the whole, it benefits society. There are two kinds of defense lawyers: the ones that live for getting an innocent client off, and those that live for getting a guilty client off. I am probably the latter kind. At the end of the day, most defense attorneys, especially those in more rural areas, believe the sentencing and fines for most offenses are outrageous, especially for indigent clients, and perpetuate a system of oppression of the disenfranchised. Marijuana possession? $602 days jail and substance abuse classes operating while intoxicated? Whether sitting in a car with the engine running because it's cold or legit drunk driving, Easily tilde $2,000 along with license suspension, increased insurance costs, and 2 days jail. Often, sentences come with 2 years of probation, which drags on with 180 days in jail if they don't do well enough. Edit. Didn't expect this kind of response. Thanks for the lovely discussion. Story 8. What I've gleaned from reading lawyer blogs, it's about defending people's right to a fair trial. Even if someone is totally guilty, prosecutors still overreach and overcharge the perp with plenty of other things they can't prove or haven't even done. The power of the state is incredible and compared to you, almost unlimited. Defense lawyers have to help make sure that you know your rights and that your rights are defended, or that you at least get something out of giving some of those rights up. Keep in mind that the state will bring on you whether you're innocent or guilty, and ideally defense lawyers will defend everyone's rights equally. One article I read that really stuck with me is from Chasing Truth, Catching Hell, com/2016/07/18/Dear Norm, How Do You Defend Those People, part 3223/, where he discusses someone accused of a heinous crime with no defense whatsoever, and answers the question, how do you defend them? What actual steps do you take? Some excerpts. First, I mentally prepare myself for the very real possibility that I will be stuck taking this case to trial. This defendant is the worst of the worst, Mr. Per-MS District Attorney may say, and he deserves nothing short of a life sentence. This may be true, but it does not relieve me of my ethical obligation to safeguard my client's rights, unless he is offered something in exchange for giving them up. Clients hurt themselves most when they feel out of control over their legal situation. Such clients feel railroaded and see their public defender as just another piece of the machine that is pushing them toward a certain outcome. When this happens, the client resists the public defender's advice, just for the sake of resisting the process as a whole. I remind the client that the decision to go to trial and the decision to testify are his and his alone, but I also remind him that he has the power to set a more realistic goal for himself. Finally, I document every decision that I make in the case as well as the reasons for it. My client will be convicted, an appellate lawyer will be running a fine-tooth comb through the record of the trial, and if I screwed something up so badly that my representation was constitutionally defective, then appellate counsel can and should argue this to the appellate court. If can't defend myself, my client's next lawyer will argue that I didn't defend my client either. I highly recommend reading the entire article. Story 9. I had a lawyer. I confessed to my grand theft auto to my lawyer, but I was with 4 others who did it. We spoke of plea options, but he wanted to wait and grant continuances to see how the other cases were built. I ended up getting off like a year and a half later. One guy pleaded guilty and got safe house, another got probation, and 2 of us got off completely. I never had to speak in court other than to ask for continuances when he was unable to make it. Then, it just got dropped eventually. I was the only one who lawyered up immediately. The guy who got safe house fell for the "we have you on video with no attorney present." There ended up being no video. If everyone had lawyered up, we probably wouldn't have got any time because we took a car for a joyride that had the keys in it, then ditched it somewhere else. Some fellow college students saw us in the vehicle and some guy stole some other guy's girlfriend, and that guy went to the cops with information since we were blabbermouths and told people we stole it. And that is what got us in questioning. This was like 15 years ago when I was in college. Story 10. An attorney has an ethical duty to represent their client zealously. That is true whether we know a client is guilty or not. Whether in court or during pretrial proceedings, we will challenge and evaluate the state's evidence. True whether trying to get a client off all charges, looking to plea, or just figure out a defense strategy. Innocent until proven guilty beyond a reasonable doubt is a heavy burden. It is a higher standard than guilty by clear and convincing evidence and by the preponderance of the evidence. The reason is simple. If the government is going to take a person's liberty or even their life, they had better not be overreaching. The burden is therefore on the prosecution. A defense attorney holds the prosecutor to that. Story 11. Not a defense lawyer, just a Fed. Clerk. But I'm in a docket with a heavy criminal docket. First off, you have to remember that most criminal proceedings end in a plea deal, so whether or not the client is guilty doesn't really matter. Your job as a defense lawyer isn't to prove they're innocent in that situation, it's to make sure the plea in an intelligent and informed way, get the appropriate benefit for cooperating, and don't get fucked over by the govt. Same with sentencing disputes. The exact details surrounding what someone did can have major implications for sentencing, even if the basic fact that something illegal happened is already established. As for actual trials, as the defense attorneys in this thread have noted, the goal is to ensure that people are adequately represented. The ideal of the U.S. legal system is that an adversarial process is the best way to establish the truth. Story 12. I think it's interesting that you see ethical questions like this for defense attorneys a lot, but not the obverse of that coin for the prosecutors who deliberately send innocent people to prison. That to me seems just mind-blowingly unethical. I guess my sympathies are more with those innocent people because I've seen several lives messed up that way. some of people I care a lot about. Story 13. Not a lawyer, but I sat on a jury for a murder sentencing trial. The guy confessed, and there were 15 witnesses who watched him shoot a young father of 3 at a baby shower while on a meth bender. I'll give his lawyer credit. He earned his fee. I think he was going for a 10-year sentence versus life. He brought in a psychologist, explaining how the guy's IQ was so low he couldn't be held responsible. Guy's mom was on the stand crying about how terrible a mother she was and how it was her fault. It almost worked. I had to convince half of the jury to switch their votes to a life sentence. Story 14. Former cop checking in. Regardless of how many people I put in cuffs, everybody deserves a right to a fair trial. It's innocent until proven guilty, not the other way around. For any defendant, whether that's Cosby, Dahmer, R. Kelly, or the old guy down the street fighting a speeding ticket, my hat's off to the defense for doing all they do. They have my utmost respect because they really do put in 100% to ensure a fair trial. Story 15. So I've commented a bunch on this thread, but wanted to chime in with an actual answer to the question. 1. What's it like? The same as it is for any other case, regardless of whether there's a confession. It means I now count amongst my acquaintances one more still alleged rapist, wife-beater/robber/drug dealer. If all you knew about me was the people I knew, you'd think I kept pretty company. How I feel doesn't matter. What I do does. And the approach to somebody who tells you they did it is frankly easier than when they tell you they didn't and swear their innocence 50 ways to Sunday. Everybody has a right to plead not guilty. So for me, anytime I approach a case, I start from the top. Was the investigation constitutionally satisfactory? That means, are there issues with the traffic stop? Defects in a search warrant? Issues with the way a confession was elicited if there was a confession? Thank Christ for clients who know to shut the up. Was the lineup correctly done? Amongst any number of other questions. Because investigatory protections aren't just technicalities for the sake of a technicality. I had a jurisprudence professor who hated the term technically, and I agree with him. Every technical or procedural rule exists for a substantive reason. If a client is guilty as sin of, say, a drug possession and there's a gun in the car and he has a violent felony, but their car should never ever have been stopped, the client doesn't deserve a guilty finding because their rights were violated. If we didn't believe that, the entire rule of law system we cherish would fall to pieces. Next question. Do the prosecutor's facts match the charges? Sometimes punching somebody in the nose is an attempted murder. Sometimes it's just an assault and battery. Sometimes a phone snatching is a robbery. Sometimes it's just interference with a 911 call. Note, not my burden. I have no obligations whatsoever in a criminal trial. One of my favorite judges, when beginning voir dire, asks the jury if they understand that me and my client can sit at counsel table and say literally nothing the entire trial. No cross, no evidence. And if the state's facts do not match every element of the offense beyond a reasonable doubt, they must find my client not guilty. Whether my client has said diddly squat to me is at this stage irrelevant. All that matters is can they prove their case using their evidence, obviously absent any tampering by me or my client. If they can't, then I sleep at night even if my guy is guilty as sin of whatever, because it's not my job to prove him innocent. It's their job to prove him guilty. Asterisk next question. And this to me is the last, and unless my client maintains their total innocence, not the most important part of case prep. What evidence, if any, do I have, or can I use to undermine their case? Note, not prove my client's innocence, undermine their case. Maybe that's evidence to attack the credibility of their witnesses. Maybe it's my client's testimony. Maybe my investigator has uncovered proof positive of innocence. And once I get my evidence, we figure out how to get it all in. 2. Do you still go out of your way to defend them? First things first, do I like my $200,000 bar license? Because if I don't go out of my way to run through all of the above steps in every case, I might as well send the pieces of my bar card back to my state licensing authority and find something else to do with my time. Second, defend is a malleable concept. As I said before, technical rules serve substantive purpose. If there's a suppression issue, I chase it. If there's a sufficiency issue, I chase it. Because not only is that the job, it's the interesting part of the job. If you've got evidence of 3 murders in your house, and that's all they've got, and the search of your house was patently illegal, there's 2 conflicting sets of moral justice, and I think OP and I fall on different sides of that. The morally right outcome is either that the integrity of rule of law is preserved, or that a murderer goes away, but I don't think you can hold both moral views about the same case simultaneously. Note aside, I have immense respect for cops, and I've never met one worth of that would allow this factual scenario to ever happen. Realistically, though, defend and win don't mean get guilty people found innocent. They mean get the best possible outcome that you and your client can agree on trying to get. Rarely that is, yes, a not guilty finding for an icky criminal. Mostly it's getting the least bad option out of a bad situation. Third, is it a problem even if I do? Frankly, I get more pissed at some non-violent offenders than a lot of violent offenders. DUIs me off a lot. I don't care if people drink, but but I care a lot if they get wasted and don't have the sense to stay put until they are good to drive. That's effectively thousands of pounds of missile you're putting into gear without sufficient means of controlling it. DUIs are a bit of a menace. People who steal and don't have poverty, drugs, or mental illness as an excuse really annoy me. No, I don't think a poor person doesn't deserve a PlayStation, and I mostly don't care about a big corporation's bottom line, but you don't get to take just because you want it and then act offended when you get called out. There are certain criminal frauds that I find personally quite offensive, and some drug dealers who drive men mad. Sorry, but why are you dealing fentanyl-laced cocaine? Asterisk, asterisk. Because the one kind of violent case that I have qualms about winning is the intimate partner violence case. Once there's a recanting witness, all bets are off. And I don't love the idea of being involved in an abuser going back to their victim. I don't. I understand it's the complaining witness's often rational choice to recant. But when I win on those grounds, I get uncomfortable because it's the one time I feel like I'm facilitating something really unpleasant. But that doesn't mean I don't do my job as best I can. Story 16. If they admit guilt, you have an ethical duty to not make false representations to the court. You have to work your best with the laws you have to make some sort of defense. You can argue that the law is unconstitutional, that he is insane, etc., etc., but you can't lie and say he is innocent. Frequently, I do not ask outright if someone did it or not. You can sort of tell. For example, you can ask, would you be willing to submit to a polygraph test about that? And if they say no, you can be pretty sure they have something to hide, unless they have another reason to not submit to one. However, most of the time, we are not arguing someone is innocent. We are arguing that the defendant should get a lighter sentence and that there are mitigating factors. There are some people I will never defend, namely child molesters, because A, I hate them too much to zealously defend them, which is a conflict of interest, and B, if I did zealously defend them and get them a slap on the wrist, I'd hate myself for it. Story 17. Everyone deserves constitutional protections. It doesn't matter what you've done. The Constitution isn't pick or choose. Defense lawyers, at least public defenders in the US, focus on that a lot of the time. Child rapists can be hard, but if you remember that the Constitution still applies, you can get through. It's a certain level of objective detachment. A defense lawyer makes sure the government isn't steamrolling you and is actually following procedure. Defense lawyers are a bulwark against government overreach, or they should be if they're competent. Also, a lot of people who do violent crimes, I believe SCOTUS just held that pickpocketing is a violent crime for sentencing determination, so violent is a legal term that can, very wildly to say the least, have fucked up lives. I know a guy who is severely schizophrenic who thought a woman was an angel robbing him, but it turns out he was mugging her with a gun and didn't realize it. He thought he was getting his money back from a thief. Public defenders, usually, try and focus on hooking people up with services and healing that they may not even know about. Also, there are loads of women specifically in prison for violent crimes who are there because they were defending themselves against their abuser and got sentenced. I personally know a woman who'd been in jail 20 years for killing her abuser who went after her child one night. Centoya Brown is another great example. These stories aren't the exception. People who commit violent crimes are still people. Not everyone is a raving, heartless monster, or Ted Bundy. Those are the exceptions, and even then, it's still not the hardest thing to defend if, at least in the US, you frame it not as letting someone guilty get off. Surprise, most people do not just get off. I really hate when TV shows are like, he got off on a technicality. Is the Fourth Amendment a technicality? Is that really what you're saying right now? Story 18. The thing about robust legal defense is it serves a bigger purpose than just keeping one guy out of jail. The state has enormous power to deprive people of their rights, freedom, or even lives. The people writ large need assurance that the state can protect them from crime, but also need assurance that the power of the state is not exercised capriciously or arbitrarily. It isn't so much that we need people to try their hardest to set guilty people free. It's that innocent people need to know that someone holds the state's feet to the fire and ensures that it punishes no one it cannot prove to a very high standard actually did the thing he is accused of. We need confidence that we cannot be hauled off in the night and subjected to a kangaroo court for something we didn't do, or our justice system becomes as big a threat as the criminals it is supposed to protect us from. Story 19. I've never really understood the hate for defense lawyers. They are a vital part of the justice system, making sure the prosecutor is doing their job properly. You know who are the true bottom feeders of society? Fucking real estate agents. Story 20. Not a lawyer. My law teacher in high school was a former defense lawyer. She quit lawyering because she defended and won a case where she knew her client was guilty for killing a child. Greatest law teacher ever. Story 21. When I started my first week of medical school, one of the dean came to chat with my class. He related a story regarding his first day in medical school ages before. His class was required to sit at their desk and contemplate something his professor had written on the chalkboard. Primum, non notare *, which in Latin means first to asterisk do no harm. Asterisk, this of course is part of the Hippocratic Oath. He told us that he felt deeply moved by this concept. Later that day, he ran into a close friend, whom he describes as being despondent and nearly in tears. His friend had started law school that same day, and was also required to contemplate something written on the chalkboard. Apparently the message written was, "The practice of law has nothing to do with justice." The law student informed the dean that an attorney's job was to do whatever was required and permitted to protect and defend his client. I still remember that lecture. It left a deep impression in me. No questions, just sharing. Story 22. Almost all clients are factually guilty of the crime. Doesn't matter. My role is to defend the Constitution and the rights it gives them. Whether or not they actually committed the crime is mildly interesting to me at best. What it comes down to is I love my country and the ideals it espouses. And the way I can give back to it is by preventing the government from becoming a tyranny. I know it seems silly, maybe romanticized, but if you don't stop the small stuff, such as an illegal search, the big stuff can creep up pretty fast. I guess I see it as being a patriot, not so much as helping a guy get away with underscore, 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 underscore. Story 23, defense lawyer here. Absolutely. The prosecution has to prove their case beyond a reasonable doubt. If they can't do that, tough for them, they don't get to send anyone to jail. That burden is always on them and does not shift to me. I am never required to work against my client. Quite the opposite. Have had exactly this scenario, have won the case, and that's the system functioning as it is supposed to. Story 24. I'm a forensic social worker. AKA, I work in prison hospitals for those who are extremely ill. I do have a few clients who I think are innocent despite jury verdict, and sometimes I have to take the stand as an expert witness to describe their mental illness. One person confessed to raping over 20 children, and as an expert witness, I had to defend him because of my client laws. I couldn't use anything he told me in trial because of the HIPAA law. On the other hand, I have had innocent people on parole where I've gone to the wall as their social worker discussing their character and who they are as a person. I've had a lot of people claim they're guilty of crimes, but at the end of the day, it's my duty to help them figure out what's going on inside their brains. A privilege all of us should be entitled to. Story 25. You have to. That's the way an adversarial legal system works. Being charged with a felony is a long process. It can end quickly with a plea or drag on to trial for years. You are obligated to present your client the evidence and give them your legal counsel. If it's bad, you tell them it's bad and that they will lose at trial. Some clients still want their trial. If your client wants their trial, you go to trial. At this point, approaching trial, some clients might have told you that they are guilty. You have to put it furthest from your mind, because you are going to have to get up in front of a courtroom and do everything that you possibly can to convince 12 people that your client is innocent. What I have observed in the more overwhelming cases, you try and beat the most extreme charges, negligent homicide or manslaughter instead of murder, etc., and you make the state earn every charge. You hold the police accountable to best practices and take them to task when they up. You put on every witness you think could possibly help your client. You put your hand on your client's shoulder and you say, "Ladies and gentlemen, my client sits before you, an innocent man." And then you give a closing argument. You have to do everything possible to prove your client is innocent or the system doesn't work. If you don't do it for the guilty, sooner or later the innocent will be affected too. I think this is what happened in New Orleans, where I work. For decades, defense lawyers worked for the judge and not their clients. So none of them ever fought for their clients. No one held the police accountable to doing a good job, and the courthouse revolved around convicting everyone brought before it, guilty or innocent. Of course, this mostly affected Black Americans because the system was created to replace slavery after the Civil War. It's called convict lease. Now it is very hard to save innocent people from the system. You can't get the prosecutors to even look at the evidence until you force a trial, which can take 2 years or longer. And when you get there, the judge is often arguing the case for the prosecution. Felonies carry extreme penalties, so you often find yourself advising an innocent client that their best chance might be taking felony time to avoid risking 30 or 40 years, or even life. I've worked in this adversarial system for 5 years, and I do not believe it's the best way to do things. There are alternatives that can provide better outcomes for victims and the accused, innocent and guilty alike. Within the system, you have to ignore whether you think your client is actually guilty and fight for their innocence no matter what. Story 26. The goal of a PD is to ensure that the state can't lock someone away without that person first having their rights defended to the fullest extent of the law. And in doing so, they create a legal system where the rights of the accused are protected. Story 27. I have absolutely no relation to lawyers, but there's a scene in Brooklyn Nine-Nine when Jake and Sophia are arguing about their jobs. Sophia, being a defense attorney, says that it is her job to make Jake prove that the defendant committed the crime. I feel that that is a very ELI 5 explanation. Story 28. My father is a lawyer. I asked him once why he didn't do family law anymore. He told me about a case where he was able to get a father full custody of his children, but by the end of case, my father wasn't convinced that his client wasn't molesting the children. Story 29. I work at a legal office. Honestly, regardless of what the person did, it's part of the job to provide an adequate defense for even the most vile of criminals. Personal feelings should never play a part. It's part of being a defense attorney. Your job is to provide a fair defense. Story 30. Technically speaking, as per the model rules of professional conduct, if a client admits to you that he is guilty, you are ethically and legally obligated to recuse yourself from the case. Obviously, this is not always followed, since it is hard to prove a defendant admitted guilt to you, but I know some attorneys who take this very seriously since their license to practice is at stake. Story 31. So I have a customer who is a defense lawyer, we'll call him Joe, and I had a long talk about this same thing with him a couple of weeks ago. Joe said that he never asks, and borderline avoids his client telling him if they are guilty or not. Knowing puts the lawyer in an ethical conundrum where he cannot put his client on the stand, allowing him to lie. Joe told me that the one time his client told him he was guilty, Joe got himself removed from the case. Story 32. The very premise of your question is flawed. We do not go out of our way to defend people. Defense attorneys defend people charged with crimes. It doesn't matter if they did it or not. Our job is to represent our client and their interests to the best of our abilities, within the bounds of the law and the ethical rules. To answer the first part of the question, it's like defending anyone else. You look at the case and analyze it, decide what the best strategy to defend your client is, and present that to them. Then you do what your client wants. If they want a trial, you go to trial. The only time it gets really dicey is when the client wants to testify and say they didn't do it after telling you they did. Ethically, you can't be a part of that. However, if they don't want to testify and there are legitimate proof problems, you point out the issues to the judge or jury and make the state prove their case. To be completely honest, I've never really cared about whether my client was guilty, just if the state could prove it. I've always felt that the toughest people to defend were the ones you knew or felt were truly innocent. Story 33. Absolutely. Everyone deserves my most zealous representation. I don't care if you cannibalized your own mother. If the police violated your Fourth Amendment rights, you're getting a motion to suppress filed, argued, and hopefully granted. The system falls apart if we abandon due process to reach the right result, even in cases where it's patently obvious what the right result is. If the police feel like courts will make an exception for sloppy work because the case is bad, and believe me, plenty of appellate courts do pull that kind of bullshit, then their incentive for doing things the right way goes down. When that happens, society as a whole suffers. Story 34. Unlike TV, 99% of crimes are not whodunits, where police have to choose between multiple suspects. Usually there's no doubt who committed the crime, so my job becomes more about protecting the client's rights and helping them get a better sentence. Story 35. I make sure I hold the government to their standards at every single level, from the cops to the government janitors to the prosecutors and judge. I don't care if the guy did it. I care if he's getting treated fairly every step of the way and not getting punished too severely. I live by Blackstone's theorem, which makes it hurt more if they didn't do it. Story 36. My friend who's studying law told me that the defense lawyer's role is not to defend a person per se, but rather to make sure that the trial is led the way it should be, according to law. Not sure if that answers your question, but that helped me understand how do people who are accused of grave crimes find anyone to help them. Story 37. The state has to prove guilt beyond a reasonable doubt. They have the burden, not the defense. Additionally, an attorney is ethically required to zealously advocate for their client and cannot minimize his or her effort. In some instances, an attorney may tell a client to not tell them what they, the client, did in order to evaluate the strength of the state's case. Story 38. Once a client has confessed in the UK, it's the duty of the defense attorney to resign from the case as they cannot mislead the court. Another lawyer will then be appointed to continue the case, assuming the client doesn't confess again. Note that at any time, the defendant can plead guilty in court to the judge if they wish. Much better to never discuss the topic of guilt or innocence, as if the defense counsel doesn't know they can keep fighting with a clear conscience and may get the defendant off. Story 39. I get this question a lot. First, I usually remind people that my function as lawyer is materially different than judge or jury and does not require me to assess guilt. If I know someone is guilty, it doesn't change my function. Please know that functional does not mean robotic or conscienceless. Second, I indicate that a court of justice is not a court of popular opinion or emotional retaliation. As a society, we have found boundaries appropriate for justice in terms of treatment and punishment under the law. Indeed, impartiality is a core concern for our judges and juries. As to the appropriate boundaries for justice mentioned above, we, as a society, have also agreed that all persons shall be treated equally under the law. Third, and aside from the core principles mentioned above, Attorneys' licenses are often regulated by state boards. Among the regulations in nearly every state is the duty for an attorney to zealously advocate for their client. It's worth noting that many states also explicitly reference withdrawing from representation if an attorney has a material disagreement with their client that would impede their ability to represent them. Conclusively, we can see that our legal system is designed to benefit all equally, and that fairness and impartiality are core concerns on the sides of both adjudication and representation. It is the special role of criminal defense attorneys to honor the principles of law before their own personal motivations. It's a duty above self thing, in honor of evolved and learned society. In fairness and with respect, the existence of your question is why lawyers must be regulated and why laws must be adjudicated by impartial persons. And one final sentiment. Many persons charged with gross offenses believe themselves to be monsters or less worthy. Many of them have been victims themselves in transformation to what they have become. And while choice is always available, you might consider the original position model of ethics as to what person would ever choose to be so despised by society and plagued with behaviors of condemnation. Mercy is meaningful, and equal treatment is cognizant that truth and reality are contextual to our immediate existence. I hope you found my answer to be beneficial to your understanding.